Josh Whitaker. This is Joe Hamer. We're attorneys with the law firm of McCullers, Whitaker & Hamer, and welcome to Real Estate Closings 101. Today, our topic is a complex topic. It's when an estate is selling property. So our seller in a real estate transaction is an estate. And so this is a complicated topic. I could probably talk about this all day in what would be the most boring day-long podcast ever created, but I won't. We're here to try to just speak to you for a couple of minutes about some of the pitfalls that we see. And so the first thing I want to talk to you about is I always talk about dead people selling property. There's always pitfalls when dead people are selling property. And so the first situation I want to put in front of you is a situation where two spouses own a piece of property together and one spouse has died. And so the trick there is if the spouses took title together, so husband and wife, spouse and spouse, but that and wife and husband and spouse language is on the deed. That's important. Then all you need is a death certificate. If one spouse has died, then you can present a death certificate, and please give it to us, because if they died out of the county, so if the property's in Wake County and they've died in some other county, we're not going to find it. You need to give it to us. But you give us a death certificate, then the surviving spouse is going to be able to sell that property without opening up a formal estate 99 times out of 100. Okay? But the important thing is there that they took title on their deed as husband and wife, spouse, married couple, tenancy by the entirety. Those key words, one of those key words has to be on there. If I took title as just Josh Whitaker and then I later got married and then I died, my wife's going to need an estate. That's not good enough. Both have to be on the deed and they have to be married on the deed. If me and my wife took title before we got married and then I die and she wants to sell the property, no dice. The law is very specific in North Carolina. You have to own it as a married couple, tenancy by the entirety. So that's the first thing I'd let you know.
Another thing is always just let us know if we're doing the closing. Just let us know that we're dealing with an estate. Arguably, if you do have a legitimate situation where you don't have a tenancies by the entirities, where you don't have to open that estate, you're dealing with heirs. The heirs are going to be they have the legal authority to sign the contract. They are the owners of the property at that point. Now, there's things that have to go into the estate administration. There's things that have to happen to give clear title and to allow closing to proceed. But generally speaking, that's who's going to be signing the contract. So one thing we'll see is a lot of times we'll get contracts that have incomplete information. So whereas there may be multiple heirs, we may have a real estate agent that's only contacted one heir. We've had one heir sign, and we'll get a contract to sell this property with the name of an heir that appears nowhere in the chain of title, in the tax history, anywhere like that, and then the property address. And that's all the information that we have. And certain counties do a very good job of having intuitive systems that allow us to look up that property and still perform a title search just based off of the address. So we can work around that. But there's some counties that aren't quite as up to date that would cause an issue, because we might not be able to match up and find who the original owner was, and it can cause problems and confusion that we're going to have to contact you to work out. So always know who your heirs are. Always know exactly who needs to sign to make it easier on us, and also to make sure that you're validly putting that property under contract and you're binding it's a binding contract that your sellers have legal authority to sell. Another thing is to always be prepared for potential issues with that estate administration. You as either the heir who is selling or a real estate agent who's helping list that property, you're not going to know what to look for always with that estate. And it's not going to be until we conduct our title search that we can look at the estate and see if everything's been done perfectly, which is the easy case, or if there's things that still need to be done to satisfy the title company. So
I will say, in my experience, 9 times out of 10, if an attorney's not handling the estate, there's something we need. It may be a simple thing, but there are always things that we need. So if you, as a listing agent, or you as an heir, if you're selling property that's been inherited, that estate is kind of like the deed. That's the way you can think of it. It's like a deed. And that's going to show how you got title. And there's certain rules you have to follow. And a lot of people don't want to pay an attorney to look at it. But once we look at it, we're not there to help you. We represent the buyer. You're the seller. We'll tell you what's wrong with it, but it's up to you. And so we've seen one here just recently where only one of the heirs signed the contract. And so we had to go to another county and track down some other heirs who were unaware that they had inherited a portion of this property. But if an attorney had looked at it, this would all have been fixed right away. The other thing I would point out to you is heirs will need to sign the contract. So if I pass away, my 3 boys inherit property, they would be the ones signing the contract to sell you property, but their spouses have to join, right? At the very last minute, the deed, the lien waiver, spouses have to join. So some people, just so everybody's on the same page, will get spouses of heirs to also sign the contract. So everybody signed everything, everybody knows what's going on. It seems like there's always, if you got 4 or 5 heirs, one of them has an estranged spouse. That spouse doesn't like the family, doesn't want to sign, and their signature's necessary to convey this property, and that trips up somebody every year, I see.
As a listing agent, you need to be in contact with these folks as early as possible. You need to be in contact with the closing attorney, or if another attorney is going to do the documents, as early as possible. Get everything signed well in advance. Get everything into that attorney so that you're going to avoid any kind of last minute issues.
We've gone a little longer than I had hoped, but again, we could go on all day. But if I was a listing agent, I was listing property that was inherited, I would almost force the heirs to have an attorney look at the estate before it went under contract. Because after it goes under contract, if something's wrong you can't fix, your guys are in breach and they can be sued. Mm-hmm. But before, things can be fixed. And so I can't stress that enough, because I would say that's the number one issue we see closings fall apart, is somebody's got a dead person in the chain of title and things haven't been done properly.
Exactly.
Yeah. All right. Well, I hope that was helpful. You could call me or Joe, 919-772-7000. If you have any questions, we try to help people with this so it's a problem now, not a problem later. Anyway, hope that was helpful. See you next time.